The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. And good afternoon. We have 3 cases that will be submitted this afternoon. Those cases are West Liberty, City of West Liberty versus Employers Mutual Casualty Company. Second case is Robert Colwell Jr. versus Iowa Department of Human Services. And the final case is Todd Morris versus Steffens Group Incorporated. Now, the last case is submitted to the court at this time without an oral argument, and we will first hear the arguments in the West Liberty case. Mr. Ruksakiati.
Good afternoon. May it please the court, counsel. My name is Scott Ruksakiati, and I represent the City of West Liberty. The issue in this case is the application of the efficient proximate cause doctrine in the context of the commercial property insurance policy issued by the defendant to the City of West Liberty, and specifically, in the first instance, whether the doctrine applies. And secondly, if it does apply, was the squirrel in this case the efficient proximate cause of the loss for which the city submitted the claim for their damage. And based upon the evidence that's undisputed in this case, and based upon established Iowa law, the answer to both questions is yes.
Let's start. First of all, you're not disputing that the immediate cause was the arcing, right?
The arcing is, you're right, the arcing is exactly what caused the
and
physical
the
damage.
squirrel is what caused the arcing, is that right?
That's exactly
and
it.
I don't think anybody disputes those facts. So then the question is, what legal significance under the terms of the policy do we attach to those facts, right?
Exactly. And I think because this is a contract dispute, we look to the structure of the contract, and which is critically important. And it's the structure of the contract which was addressed by this court in the Amish Connection case. In that case, the court recognized that there are 2 separate types of exclusions. The first type of exclusion is introduced by what courts across the country and in Iowa have termed anti-concurrent cause. In other words, if a loss is caused by more than one peril, one cause of loss, and one of those causes is excluded, it doesn't matter what sequence those causes occurred, the entire loss is excluded.
Let me quote some of the language that I think is relevant
Yes.
in Amish, and then I'm going to ask you about it, if I can find it here. Amish, we said, when insurance policies lack an anti-concurrent cause provision, here's the language, we've held an accident that has 2 independent causes, one of which is covered and one of which is excluded, is covered unless the excluded cause is the sole proximate cause of the injury. The thing is, reading the facts and the case law here, it doesn't strike me that there are really 2 independent causes. There's you don't have the squirrel that caused the incident. You have the squirrel caused the arcing, caused the incident. So it's all one chain, which is what the district court said.
Exactly. It is all one chain, and that's why the facts of this case fit squarely within the rule that was articulated in the Qualls case. There, the court said, where the peril insured against sets other causes in motion, which, in an unbroken sequence and connection between the act and final loss, produces the result for which recovery is sought, the insured peril is regarded as the proximate cause of the loss. No, it did not. It didn't. But what that did is, 47 years ago, basically clarified the efficient proximate cause, and Iowa joined what is essentially the majority of courts in the United States which follow and have adopted the efficient proximate cause doctrine in this context, in the property insurance context. And so when you take our facts, the undisputed facts, that the squirrel, which is an insured peril, and that's not disputed, and it's not disputed, we know that because as Justice Mansfield, you pointed out, they haven't disputed it. It started in their answer. It even appears in their chart with the cartoon that the squirrel is a cause. Absent the squirrel, none of this would have happened. They are so inextricably tied that if you don't have the squirrel, you never have the arcing, you never have the damage.
With any time you have an exclusion, there's always going to be some event or something prior to the exclusion that's going to cause that excluded event. Are you saying that if there is a prior event like that, that then the exclusion doesn't apply?
Yes, that's exactly what I'm saying. In jurisdictions such as Iowa, which have adopted efficient proximate cause, and we're out of the context of anti-concurrent causation, because that's the way that an insurance company like the defendant can contract out of the efficient proximate cause. They didn't do that here.
These aren't concurrent. I mean, the facts aren't a concurrent cause. A concurrent cause, normally you think of two things that come from independent sources and jointly contribute to the incident or the accident. Here you have one single chain: squirrel, arcing, accident.
That's exactly right. That's exactly right, and I think that's why both the majority and Justice Doyle, in his dissenting opinion, recognized that this is somewhat of a unique case, and that's why Justice Doyle made reference to that New York case, the Continental versus Arkwright case, and that's the case where there was flooding, that floodwaters entered the building and came in contact with the electrical panels, causing electrical arcing. And the argument was, by the defendant, by the insurance company, that the flooding, the water, didn't cause any damage itself. It was the actual arcing that caused the damage. And that court said, because of the immediacy of those two causes, that you could not simply look at the case in a vacuum and look at the most immediate cause, which was the electrical arcing, but what immediately set this entire chain of events in motion.
You know, what would you do if there was a strong wind and it blew the two wires in together to cause arcing?
Yeah, and that's actually a situation we thought about. And you know, if a tree fell and came in contact with the electrical arcing, came in contact with the electrical transformer and caused arcing, that too would then trigger the efficient proximate cause analysis. And in that case, because a tree falling on the transformer would be a covered peril, and there would be an excluded peril, the electrical arcing, you'd have to look at what caused it. What was that initiating factor?
Tell me when the exclusion would apply. Give me a fact situation where it would apply.
It would apply if, in fact, there was some power surge for some reason. And I'm not an engineer, I can't tell you how, but if there was some power surge that caused this electrical transformer to overheat, to do something that causes the electrical arcing.
What if the power surge was caused by someone at the plant pushing a wrong button?
Then you would look again to see if someone's negligence, an employee's negligence, was a covered peril, and you'd then do that efficient proximate cause analysis.
There's a case, it got a lot of notoriety at the time, the insurance coverage litigation over Hurricane Katrina in New Orleans.
Right.
And one of the arguments they made, it seemed to me, was similar to what you're saying, what you just said now in response to Justice Wiggins. They said, well, in some of these policies, there's no anti-concurrent cause provision. And although flooding was the immediate cause of everything that happened, there was negligent operation of the levees that led to the flooding. And negligent operation is was the, quote, efficient proximate cause. And the court said, well, no, that only applies when you have two independent causes that contribute to the event.
My recollection of that case is I think it's different. I thought the court did look to see whether or not flood was the cause, because there was a question in that case of whether or not that flood exclusion was ambiguous. And so the court devoted a lot of time discussing ambiguity and eventually concluded that flood was not ambiguous. And so because the loss was caused by flood, and there was anti-concurrent causation language in that insurance policy, that's my recollection, that it was excluded, and they never even reached the issue of the negligence of the Army Corps of Engineer in designing the levees. We actually had another case subsequent to that. It was another case that arose out of Katrina, Corps versus Commonwealth Insurance. And in that case, the issue, it was similar but different. The issue in that case was the insurance company wanted to apply 2 different deductibles, one for windstorm and one for flood. And the policyholder who we represented argued that only the deductible for windstorm should apply and not flood, because windstorm was the initiating event which caused the flood. In other words, without the named windstorm, you wouldn't have a flood. And the Fifth Circuit agreed with us. That's a case that's subsequent. I don't have the citation, but it's Corps versus Commonwealth Insurance.
I agree with you that Katrina deals with that question about whether flood's ambiguous, because I think I taught contracts one year and it was in the case book for that proposition. But I also think it covers this issue. The Fifth Circuit, let me quote their language. The court says, nor need we address the operation of the efficient proximate cause rule itself in this case. The efficient proximate cause doctrine applies only where 2 or more distinct actions, events, or forces combine to create the loss. But here, on these pleadings, there are not 2 independent causes of the plaintiff's damages at play. The only force that damaged the plaintiff's properties was flood. To the extent that negligent design, construction, or maintenance of the levees contributed, it was only one factor in bringing about the flood.
Right. And I think in this case, there were in fact, 2 independent causes. It was the squirrel and it was electrical arcing, because as I said before, without the squirrel, you don't have electrical arcing. I think what the trial court ruled, and it's an argument that's been raised by the defendant, is that initiating act must cause some type of independent damage. And that's not any feature of the rule that's been articulated by this court.
So it doesn't matter whether the squirrel gnawed through some insulation to cause the arcing, the arcing happened.
Yeah, and it doesn't, because the squirrel, again, was an integral part of this whole sequence of events. Absent the squirrel, no arcing. And I think what's important is the Qualls case, just the facts of that case. Because in that case, and that's where the court articulated the efficient proximate cause doctrine, in that case, there was coverage for loss of livestock due to an attack by wild animals or dogs. Yet, it was undisputed that there was no physical manifestation of any such attack. There were no bite marks, there were no scratches, nothing. Yet this court determined that an attack by wild animals or dogs was in fact the proximate cause of the loss based upon some expert testimony. So in that case, the court wasn't looking for any type of independent damage. They didn't focus on that. And that's why in none of the cases has the court specifically articulated the rule that, I just want to get the language correct. The rule is not stated in Iowa, nor is it stated anywhere else, that the event must cause independent damage and then causes the entire sequence of events to occur in an unbroken chain leading to the loss. It's not that specific. That's a much more restrictive standard. Now, granted, in most of the cases that have been presented to this court, and cases in other jurisdictions, there have been 2 separate independent causes. The first cause causing some damage itself, and then there's a second cause causing damage. And probably the most exaggerated example of that is that Bettis case. And in Bettis, that's where the tractor hit a culvert, damaged the suspension, and then later, while that tractor was being towed, the transmission was damaged. And there, the Court of Appeals, applying Qualls and the efficient proximate cause doctrine as articulated there, said that the efficient proximate cause was the damage that was caused when that tractor struck the culvert. And so looking at that spatial and temporal attenuation and comparing it to our case, I submit that if that fact pattern, in that fact pattern, that damage to the tractor could be the efficient proximate cause of the transmission damage, that certainly in this case, where the squirrel's actions and that electrical arcing and damage were so immediate, and as I said, inextricably tied, the squirrel must be considered to be the efficient proximate cause.
So
What
for
was
the
the-
policy to exclude an incident like this, it would have to say that it would exclude loss caused by arcing when a foreign object completed the electrical circuit or something like that?
Actually, it's much more simple than that, Justice Cady. What the insurance company could have done in this case, is to place the electrical currents exclusion within the first category of exclusions, which is introduced by the anti-concurrent causation language. That's how you avoid the application of the efficient proximate cause doctrine, and that's what's discussed in Amish Connection. So for those reasons, the efficient proximate cause of the loss was the squirrel, and I will save further comment for my reply. Thank you.
Mr. Ruksakiati, thank you. Mr. O'Brien.
One moment to set up, please. May it please the court, counsel? They say a picture is worth 1,000 words, and it's not often that I get to work on a case where we have a picture of the loss. This came from a report by Bob Basil, a consultant who investigated the cause of this loss. And I venture to say that if you saw this for the first time and the resulting damage to the electrical cables in the form of melting and the vaporization of the equipment box for the transformer, you would say, wow, look at that electric event. And I also venture to say that none of you would say, wow, look at all the damage that squirrel caused. And ladies and gentlemen of the court, I would submit to you that that is why the judgment of the district court and the Court of Appeals should be affirmed in this case. We raised three main arguments in our appeal. First, that the efficient proximate cause does not apply in a situation here where only one peril, electric arcing, caused damage. Second of all, even if the efficient proximate cause doctrine does apply, electrical arcing must be deemed the dominant cause of the loss under Iowa law. And then our third and final argument is that the structure of the electrical currents exclusion effectively creates an anti-concurrent causation provision. So let me begin my argument with the insuring agreement. This is an all risks policy, and it uses standard all risks language. It says that this policy covers direct loss to covered property caused by a covered cause of loss. And then the policy defines a covered cause of loss as direct physical loss unless accepted or limited by the policy language. That language in the insuring agreement is significant for what it says and what it does not say. And it all deals with the word direct. It requires a direct loss, and indirect loss does not trigger coverage under the insuring agreement. So here we have an electric currents exclusion that is at the center of the argument in this particular case. And that language, and you have the copy of it in front of you, says we don't pay for loss caused by electric arcing. Now, we would submit that the loss in this case is the electric arcing damage, and then the exclusion applies. Of course, the city takes a different posture and says the true cause of this loss is the squirrel who initiated the arc. Well, we can agree that the squirrel initiated the arc we can also agree that the only damage that the city seeks to recover in this case is damage for electrical arcing. And so how does that play in to the coverage analysis in this case? Let me begin by just a general discussion of concurrent causation principles. That doctrine is invoked if we have two alleged causes of a loss, one of which is a covered peril and one of which is an excluded peril. And courts have come to different conclusions as to how to resolve those type of situations. One would be the concurrent causation doctrine. And under that doctrine, when two or more causes contribute to a loss, at least one of those causes is a covered peril, there will be coverage unless the insurer can show that the excluded peril is the sole proximate cause of the loss. An alternative approach is the efficient proximate cause doctrine. That doctrine seeks to determine the predominant cause of the loss, and then we look at that cause and apply it to the policy language. If the predominant cause is a covered peril, there's coverage. If the predominant cause is an excluded peril, no coverage. So, the other alternative would be an anti-concurrent causation provision that would be a leading clause to the exclusions. Iowa courts have recognized that as an exception that would trump the efficient proximate cause doctrine or the concurrent causation doctrine. And the magical language would be something to the effect of these exclusions apply regardless of any cause, concurrently, or in any sequence that contributes to the loss. So, how do we apply these principles under Iowa law?
I mean, do we need to get to all of these principles? I mean, that's, I mean, it's just as a basic matter of contract law. If I tell my son that if he's home late, he's not going to get to do something. I don't care about the reasons why he's home late. They could be all kinds of different reasons. He's home late. If the policy excludes electrical arcing, does it really matter what caused the arcing? It's not, we're not dealing with two independent causes that are contributing to the loss. One thing caused the loss, and something else may have caused the thing that caused the loss, right?
Right, and we agree with you that in this particular case, you don't even need to get to the efficient proximate cause doctrine because of the electric currents exclusion. So, we agree.
How would you answer the hypothetical? I realize it's not the facts of this case, but windstorm topples tree, which causes the arcing. Is there coverage for that?
Well, if the windstorm toppled a tree and the tree caused damage, then maybe we could get into that analysis because now we've triggered it. There's damage by the tree and there is also damage caused by electric arcing. So I think that's the distinction here, is that the squirrel didn't cause any independent damage. There was a hypothetical posed earlier during the city's argument where what if the wind blew the wires? Well, the question I'd want to know there is what independent damage did the wind cause in that case? Wind blows all the time in Iowa. We don't have an insurance claim anytime there's wind. The wind has to cause damage in order to trigger
If the squirrels
coverage.
chew through the wires, would that be covered?
That would be a different analysis because the squirrel has independently
Or would it be
caused
covered?
damage. Potentially. What we would have to do then is go and apply the efficient proximate cause doctrine to the facts of the case.
When you held that picture up, I thought fire, and that's an exception to the exclusion. Has anyone argued in this case that this was a covered fire damage?
That was the initial argument we thought would be raised by the city, and in Mr. Basil's report, he addresses the fact that really what you're seeing in this picture is an electrical arcing event and a plasma field as opposed to a fire. That argument was never raised at the district court level, if I recall the briefing correctly. I know it was not raised at the Court of Appeals level.
So it's not in play.
Not in play here. I did want to clear up one potential point of confusion, and this is the court raised this in the Amish Connections case about the different potential applications of concurrent causation. And I would submit to you that you do a synthesis of Iowa case law, what you would find is that the concurrent causation doctrine is the rule that Iowa has applied in third-party liability cases. and that in first-party property insurance losses, like this particular case here, the courts have applied the efficient proximate cause doctrine. The reason for the distinction is that in a third-party liability case, the insuring agreement, the trigger of the insuring agreement is the legal liability of the insured. So the focus in that type of a coverage analysis is on tort liability. But in a first-party case, the trigger is the direct physical loss that I had mentioned earlier. And if you were to apply the concurrent causation doctrine in first-party property cases, you're essentially swallowing up all the exclusions, because we could always find something that might be covered in the sequence of events that led to the loss. So that's the rationale that the insurance commentators have given for the distinction between those two rules, and I just wanted to make sure that we got that clarified. Now, I don't believe that we even need to get to the efficient proximate cause doctrine in this case. And that's because in the case law in other jurisdictions and implicit in the case law in Iowa, there has to be two independent causes of damage before we even get to the analysis. The main case I rely upon from other jurisdictions is the In re Katrina Canal case that was addressed earlier. And then both Appleman and Couch inform us that if a peril causes separately identifiable damage, then the court need not delve into an efficient proximate cause analysis. It's just another way of saying the same thing. So I wanted to
Could you distinguish the Qualls case that opposing counsel relies heavily on?
Certainly, and let me refer you to my chart. I tried to come up with a way to illustrate how Iowa courts have applied the law. In the Qualls case, the insured property was the cattle's, and in that particular case, the policy was essentially a named perils policy, and it covered loss of livestock by attack of dogs or wild animals. And in that particular case, the evidence suggested that there was a bite by some wild animal that caused an infection that led to pseudo-rabies, and pseudo-rabies was the cause of the cow's demise. In that particular case, the court applied the efficient proximate cause doctrine and found the remote cause, the wild animal bite, to be the efficient proximate cause of the loss. So that would be an example of where a remote cause would be one of the or be the efficient proximate cause. But if you look at Iowa case law says we go and try to determine what the dominant cause is. It can be the remote cause, or it can be the immediate cause. And another example I have up there is the Vorse case. That was a policy that provided coverage for accidental breakage of plate glass. And the policy had an exclusion for loss caused by fire. In that particular case, for reasons unknown, they were using gasoline to clean clothes. And the evidence suggested that someone lit a match. And then when they lit that match, it ignited an explosion, and the concussive force of the explosion shattered the plate glass. Following that, there was an ensuing fire. So the coverage issue was over whether there would be coverage under the policy for the damage to the plate glass. And the court found in that particular instance that the explosion, the immediate cause, was the efficient proximate cause of the loss. Why did they come to that conclusion? Because striking the match didn't cause any independent damage to the plate glass. The only damage to the plate glass was caused by the concussive force of the explosion. That's a covered peril under the policy, and the court found coverage. So if we go through our cases, Bettis is a similar approach, where we have a policy that provides coverage for direct loss resulting from overturn or collision. So we have a tractor that runs into a culvert, and there's damage to the tractor. They forgot to turn the engine on or off. I'm not a mechanic, but apparently when they towed it, they did it in a way that caused damage to the transmission. And in that particular case, the issue was, is that transmission damage going to be covered under the policy? And in that case, the court again applied the efficient proximate cause doctrine, and they found that the collision with the culvert was the efficient proximate cause of loss. Again, though, that collision with the culvert caused independent damage to that covered property. It stands in contrast to the Clasing case. And the Clasing case is a situation where we have a hog confinement facility. It was a winter storm. The winter storm caused some icing of some draft curtains and a power outage. When the power cuts, the curtains are supposed to drop and permit ventilation so that the hogs can continue to subsist. In this particular case, because of the ice accumulation, the curtain in one of the barns did not drop. And the hogs died, and then they died in that case from either suffocation or hyperthermia, meaning they just got too hot. So the coverage issue in that case, again, is what was the efficient proximate cause of that particular loss. The Court of Appeals applied an efficient proximate cause analysis, and they ruled out the winter storm and the icing event as a cause of the loss. And again, why would they do that? Because it didn't cause any independent damage to the hogs. The hogs died from either overheating or suffocation. Now, there was a factual dispute in that particular case as to which one of those causes was the cause of death for those hogs. Only one of those was excluded, suffocation. So the court got sent, their case got sent back to the district court to litigate the causation issue. But in any event, again, that's an example of a situation where we did not have any independent damage caused by the remote peril, and the court found that that could not be the efficient proximate cause. So when we apply that type of analysis to our particular case, if you're going to apply the efficient proximate cause doctrine, we would submit that our case fits in neatly with the Vorse and Clasing decisions, where the squirrel by itself didn't cause any independent damage to the electrical equipment. That damage was caused by electrical arcing, the excluded peril. I believe that's all the time I have, so thank you for the opportunity to clarify this interesting issue of insurance coverage law in Iowa.
Mr. O'Brien, thank you. Mr. Ruksakiati?
Just to address quickly Justice Waterman's question about the fire, I too, when I first saw the pictures, I thought, yes, this is a fire. To a layperson, you see orange and it looks like a fire, but we engaged an expert and the expert said no fire. So, but in this case, it's our position, it doesn't matter. And I just want to clarify one point that counsel raised, and it was the discussion about the dominant cause, because I don't think that the rule was expressed correctly. And I'm pointing to the Bettis case. Again, that's the tractor that hit the culvert and was damaged. And there, at the court, the appellate court, in quoting Quall, said, "The dominant cause may be concurrent or remote in point of time or place. Thus, we look not necessarily to the last act in the chain of events, but rather to the predominant cause which set in motion the chain of events causing the loss." That's the dominant cause. And that rule fits right into the expression of the efficient proximate cause rule that this court articulated in Qualls. And what I tried to do this before, I don't know if I articulated it correctly, but if we take our fact pattern and put it into the rule expressed in Qualls, it says, "The squirrel sets other causes in motion which, in an unbroken sequence and connection between the act and final loss, produces the result for which recovery is sought. The squirrel is regarded as a proximate cause of the loss." It's the dominant cause. If you don't have the squirrel coming in contact with the transformer, there is no damage. And as I said before, the way in which insurance companies like the defendant can contract away from the efficient proximate cause is to insert the exclusion in that first category of exclusions in this policy that's introduced by anti-concurrent causation language. The second category of exclusions, where the electrical currents exclusion applies, does not contain and is not introduced by any anti-concurrent causation language. In terms of independent damage, it may be that in most of these cases, there is some independent damage that was done. And that may just be facts of the case. But this court, nor has any other court specifically articulated when discussing the efficient proximate cause rule that the event must first cause independent damage and then set everything in motion. That's just not the case.
Counsel, I'm surprised there aren't more reported cases involving rodent or squirrel damage, because I understand it's not uncommon that the transformers are exploded and whatnot, the rodent doesn't survive, but then there's some damage.
Yeah, I share in your surprise, and I think the appellate court was surprised as well. And as recently as yesterday, I did another gut check, and I did not find any case on point. This case really is the first case in the United States dealing with this type of fact pattern. And I would emphasize that for this court to require the squirrel to independently cause damage as a prerequisite to the application of the efficient proximate cause would essentially be creating new law and would take Iowa from the majority of jurisdictions which apply the efficient proximate cause as articulated in Qualls and really put it alone. It would be the singular decision requiring independent damage. And I submit that this court should decline the invitation to create new law, apply established Iowa law regarding the efficient proximate cause doctrine.
Should we worry that we would be, in effect, writing out of the contract the exclusion for arcing? We have arcing damage here, and now if we're going to set that aside because of the event that started the arcing, aren't we rewriting the contract?
I don't think it's rewriting the contract, and there may be other situations, and again, I'm not an engineer, where electrical arcing could be caused without some external cause. There may be, I just don't know that. But what I can say is that in order to avoid this situation is for the insurance company to place this exclusion in that first category of exclusions under the anti-concurrent causation language. And had they done that in this case, we would not be here today. And so for all of these reasons, the city requests that the court reverse the lower court's decision, grant judgment in favor of the city on the issue of coverage, and return the case to the district court for further proceedings regarding damages. Thank you.
Mr. Ruksakiati, thank you as well. And Mr. O'Brien, thank you again. The case of City of West Liberty versus Employers Mutual will now be submitted, and we'll next hear the arguments in Cowell versus Department of Human Services.